Hi everyone, and welcome back to this week's episode of Digital Law News. So I'm Laura Spencer, and I'm joined today by my colleague Peter Wright. So just for those who don't know, Digital Law is a niche law firm based in the UK, and we specialise in all things to do with data protection, technology matters, cyber law, social media law, and so on as well. So I'll just pass over to Peter to give himself a little introduction before we get started with today's news articles.
Thanks, Laura. I'm a solicitor and managing director with Digital Law. And as Laura says, we do a lot of work around everything from e-commerce, data protection, international data transfers through to social media law and everything really associated with running your business in a digital environment. And we've got a few really interesting stories for you this week. So I'll hand back to Laura to start taking us through.
Great, thanks, Peter. So yeah, the first story today is in regards to Google's Incognito mode. So this is in regards to a lawsuit that is currently being undertaken against Google. In fact, their parent company, Alphabet. So basically, a $5 billion lawsuit has been approved because Google has been under fire recently for harvesting internet data of users while browsing normal mode, just like on your normal Chrome, but also while incognito mode as well. So if those of you who don't know, incognito mode is kind of like a special setting on the Chrome browser, and it basically, if when activated, it kind of boosts your privacy, and it doesn't save the session to your history about history of your browser. So anyone who goes on the computer after you kind of can't see what you've been looking at. So I think it's the whole level of this incognito mode is seen to have the added privacy on top of what you should already have while using your personal PC. But yeah, the Google have found to be collecting this data and compiling it. So the class action lawsuit is being undertaken in the US, and it is against their parent company, Alphabet. So yeah, that's basically everything about that.
Thanks, Laura. I mean, I find this story quite fascinating because, of course, I think an awful lot of users who are familiar with using that incognito mode will have probably had reason to think, given the name of it being incognito mode, and given the symbology when you click on the little button and it goes grey, and you've sort of got the idea of it being, you know, a pair of shades on, that sort of thing. There's a lot of imagery behind when you use the incognito mode. I think you would have had reason to believe that what you were looking at online was then private to you and wasn't then being shared with Google and wasn't being used for their usual marketing and analytic purposes. And yet, surprise, surprise, turns out they were doing that all the time. We shouldn't really have been surprised. You know, Chrome is designed to be integrated with the Google search engine, and of course, it's designed to be gathering as much data as possible to allow the production of those search results. And turns out, yeah, they were looking at that data, keeping it, processing it, doing various different things with it all the time. So, I mean, in terms of where this lawsuit is, we're looking at approximately $5 billion in value. It's been approved. I think Google have made an attempt to stop the suit from moving forward, which has been unsuccessful. So it's likely now that they'll probably end up settling with those who are within the class rather than letting it go to a full trial. Reasons for that is that if you went to a hearing, it would cost everyone huge amounts of money and time, and it would also mean that some of their fairly confidential things, or certainly confidential as far as they're concerned, would be shared in open court. So giving everyone else, all of their competitors, a view on some very technical technical insights with regards to how the Chrome browser works, not to mention probably terrifying most of the users. I think we have to bear in mind the ubiquity of the Chrome browser. I mean, this is kind of the go-to browser on most people's laptops, desktops, Android devices, so tablets and phones very often come bundled with the Chrome browser. So there are hundreds of millions of people who use it on a regular basis, and hundreds of millions of people who've probably been using that incognito browser thinking, ha ha, It's on this setting, no one's looking at me. Well, surprise, surprise, I'm afraid they were all the time.
Yeah, exactly. I think it just makes it obviously Google compiling all this information and keeping it for a long period of time. I don't know if that's been the case or anything, but keeping this information of just what people are browsing on a daily basis isn't very. I mean, your browser history can tell a lot about you as a person in terms of like where you shop, what you do, like your lifestyle, everything like that. It might give away like eating habits in terms of like allergies and things like that. So it's a lot of sensitive personal information. But I think it's the fact that we assume that because it is Incognito, it's private. So you would not assume that it would be seen. But I think it's worth highlighting here as well the fact that they've had to bring a lawsuit to kind of get this action. Like we've always mentioned about how the US stance to that data protection and everything is always different to the UK in terms of they don't have Gdpr or anything. Well, California have now like a similar one, but it's not the same in terms of like the regulation and everything. So that in the UK, obviously the ICO or a different regulator would usually take action against the company. Whereas if anything does happen in the US or some other countries around the world, the only way to bring an action against them is a lawsuit like this.
Exactly. Let's not forget that Google was the first organisation to receive a massive multi-million euro fine, 50 million euro, when GDPR was first introduced. And I think the European data protection regulators will be looking very carefully at this court case, probably looking at any evidence that is disclosed. Or any findings of fact that may come out as it continues to progress, because that could then give them evidence to make their own regulatory decisions and regulatory enforcement against Google. I think there is the element of data being collected without it being, without users being aware, for a starter. So what's the basis upon which that's being processed under Article 6, which one of those 6 basis is being used? Certainly looks like if it's incognito, you couldn't argue it's consent. They might argue it's contract under the terms, but this is the sort of thing that arguably if you go into incognito mode and that data is being processed, it would have to be a different basis compared to if you were using the regular settings on the browser. Not to mention then things like, you know, is that data being subject to onward transfer? Is it going to other parts of Alphabet? Is it going to other third-party contractors? Is it going to other jurisdictions? And how long is it being retained for? I think all of these questions would need to be subject to quite serious scrutiny, and it could be that one of the European regulators, probably having looked at this at the European Data Protection Board level, may then feel the need to take action. If they don't, it almost suggests that they were aware of this already, and that Google may have closed this following that original 50 million euro judgment. But the fact that remains that you know, people have been under the impression generally that, oh, if I was incognito, no one was looking, and certainly there have been no guidance to suggest that wasn't the case. So I think it would be difficult for any of the EU regulators to actually not take action on the back of this. Whether that action takes the form of a monetary penalty notice or something else, well, we'll now have to wait and see. Yeah,
exactly. Yeah, I think there'll definitely be some type of investigation, or at least some consideration into if any EU or UK regulators are going to look into it.
Yeah, that's a good point as well. There could be the Information Commissioner now, of course, is regulating things in their own right with regards to the UK, and they may make their own independent action entirely separate of anything the EU does.
Yeah, 100%. So the next story is in relation to a Bitcoin scam. So this is a Bitcoin scam that a gentleman called Sebastian actually fell for. So this was a fake giveaway by Elon Musk, and basically Elon Musk tweeted, probably his account got hacked or something along the lines, but he tweeted a tweet and then posted a link below and said, basically, I'm giving away Bitcoin. If you put so many Bitcoins in, I'll double it and then transfer you the Bitcoin back, basically. So Sebastian clicked on the link and thought, why not take part? So he decided to give 10 bitcoins, which was worth around £400,000 at the time, and then sat and waited until the countdown counted down, got to the end of the countdown and realised that it was all a scam. And then he had to go upstairs and wake his wife up and tell them that he just lost their entire life savings and absolutely everything. But I think the main point here is to just highlight the fact that it can be anybody who falls for such a thing like this. I think we spoke about it a lot, especially in different training that me or you, Peter, have provided in terms of like phishing or scams and things like that, but how easy it is. I know you received a phishing message a couple of years ago in regards to council tax, and you had to even double check, even though you know a lot about phishing and what to look out for and everything. And I think it's just highlighting the fact that anybody can. And as much as we wouldn't usually see a Bitcoin giveaway just posted on a random Twitter feed, yeah, it's just that reminding people that it is easy, and just to double check the source of where this is coming from before you actually do anything.
Indeed, Laura, yes, and I did receive a phishing SMS scam text message saying you've not paid your council tax, and of course anyone who receives something saying you haven't paid something, you haven't done something, you immediately sort of have that moment of that sharp intake of breath. And I went and queried to check, and of course we had paid it. And then my wife went, have you checked what it says on that text message? And when I looked at it, it said London Borough of Ealing. I don't live in London, so that should have been the big giveaway. But very often people receive emails that report to come from the bank, and it's only when they sort of check which bank it is and they think, oh yeah, I don't bank with them, that makes you sort of stop and sort of check yourself, as it were. And unfortunately, the gentleman in this story, and I can recommend looking at the full story on the BBC News website. Just literally type in that Bitcoin fake Elon Musk giveaway, and you'll see this story, which was published this week. I mean, he was taken in because it was a tweet that was posted on Elon Musk's personal Twitter feed.
Yeah.
But the account had been hacked along with a number of other celebrities. So at the same time, the hackers had gained access to a number of other high-profile celebrities and various big personalities on Twitter. And they were all talking about this big giveaway, which of course was trending. And unfortunately, this gentleman ended up being taken in by it. I think we need to highlight the fact as well that he did work in the IT industry. So he was looking at this from, he's putting on his tech hat. He's familiar with all the terms. He went and actually checked on the website, is this a genuine website? Saw the countdown timer, saw what he thought was evidence of other people interacting on the site and handing over their coins. So this is all perfectly valid and genuine. This was also an individual who'd actually done very well out of originally investing in Bitcoin, had got their original investment back and then seen that stake increase tenfold. So they'd done very well out of Bitcoin. And unfortunately, though, when someone says double your money, he thought, well, why not? And that's exactly what he did. And unfortunately lost the whole lot. And Laura, you described the fact he had to go upstairs and then tell his wife what had happened. Yeah. And I'm sure that came as a real shock to her, as it would to anyone. And I think he was just so shocked himself. Apparently, there were white hat hackers and people in the industry watching this scam in progress who couldn't stop it, but they watched aghast as they were able to trace and follow his £400,000 worth of Bitcoin traveling through the ether to the fraudsters, and then disappeared from that point on. And that was the largest individual transaction as part of this hack. I mean, very often these sorts of scams will net the fraudsters, tens of thousands of pounds, perhaps 100, 150,000 pounds, or comparable amounts if they're lucky. But in this instance, it was this £400,000. So they must have literally not been able to believe their luck. But it's a salutary lesson. And I keep thinking about, we talked the other week, Laura, you'd received that, what you thought was a phishing SMS message from the NHS about vaccination. Yeah. True, and you were able to get your vaccination. But you didn't click on the link. I think the takeaway from this is always to say, if you do receive a communication that you're not entirely sure of, do not click on the link. If it's a link on a tweet, if it's a link on an email or an SMS, do not click on the link, on that link. If you think it's genuine, you know, carry out a few searches yourself and find another way into what could be a valid, genuine link, rather than just clicking on something that's been sent to you that could very easily be a scam being perpetrated by fraudsters. Let's not make it easy for the fraudsters is the message I think we need to take away from this.
Yeah, absolutely. I think that's always the best way. Even if you do think something is genuine after doing a little bit of research, or maybe even specifically speaking to the bank, if it is from the bank, or speaking to your doctors or anything like that, it's always better just to say then logging into your online banking or log into, say, the NHS website directly to try and book then or add the information that they're requesting, rather than just clicking on the link. Because even then, it could be the bank generally wanting some information, or somebody else generally wanting some information, and you know about it, but that email could still be false. So yeah, just always double check and go around it a different way.
Yeah, I think it's worth remembering as well the apocryphal story of Hillary Clinton's campaign manager, who back in 2016 received what he thought was a scam email trying to gain access to his Google email account. He forwarded that to the campaign manager, to the IT manager for the campaign, said, "Is this a scam?" IT manager replies back and says, "Yes, it is. Therefore, I suggest that you change your password information, change your login as a matter of course, just to make sure that you're maintaining access and not giving anyone else access." And the campaign manager said, "Yeah, thank you very much, I'll do that." But then unfortunately, rather than just clicking on the little cog wheel in the corner and changing the settings there, they scrolled down within the body of the email exchange they just had and clicked on the fake link that had just been sent as part of the scam. And then they did give access to the hackers. We know, unfortunately, the consequences of that. So that was as a result of what they think was hacking being undertaken by a collective in Russia, whether it was associated with the Russian state or not. Well, led to believe it might have been. But the point is that all that damage was caused by just clicking on the dodgy link rather than on the genuine article. If they had gone and just reset their own password, they would have been fine. And it's the salutary lesson: use your own verified information rather than just clicking through emails, SMSs, or texts or notifications to make sure that you are not giving access to the fraudsters.
Yeah, absolutely. So moving on to the next story then. So this is in regards to the foreign and defence policy that was released over the last couple of days. And it's basically about the trends and the new things that they're going to be looking at. So the main point of this story is saying that the national power now isn't defined by the numbers of tanks and by the military presence, but rather by its science and technology and the quality of algorithms. So I think it's just showing a shift in terms of towards technology. So this was integrated into the review that is mentioned in the article. So it goes into detail about how the UK's first goal is growing the UK's science and technology power in pursuit of a strategic advantage. And it says how £6.6 billion of the defence funding over the next 4 years will be going on research and development. A new cyber strategy could see more frequent offensive capabilities by the new National Cyber Force. And it also goes into detail about the AI and the UK having cutting edge research on this. There is one criticism in the review or the report, and it's basically saying how UK tries to have it both ways with a lot of the countries, and they're finally realising that some countries are more of a threat than a help in some ways, especially when it comes to China, and that's saying how the Huawei 5G telecom shows that some hard decisions have to be made sometimes in terms of like growth in technology matters.
Indeed, I thought this was a fascinating report, and it's worth a read through in its entirety, but in particular we wanted to focus on the commitments made with regards to the cyber strategy and the National Cyber Force. In America you now have Space Force, we have Cyber Force in the UK, because this is seen as very much the new frontier in terms of offensive and defensive capabilities for nation states. I was almost reminded when I was reading through this of the in World War II, a number of states had built huge expensive battleships thinking that that's where the fight would be on the oceans in any coming conflict, and it turned out that the battleships, these huge cities of steel, were obsolete before they'd even been launched, because it turned out that all you had to do was have an aircraft carrier with a few dozen planes on there, and that could easily knock out said battleship. Indeed, the Bismarck ended up being sunk as a result of a little torpedo launched off a biplane, and it just kind of showed the damage that could be caused by the new technology that was taking over the old. And this is the same sort of thing. This is showing that when it comes to having it's not a matter of saying, no, we'll just launch an algorithm on you and leave it to that. This is more the idea of offensive cyber capabilities that could, say, knock out a electric grid. Not so much just put a country into a power cut, you could actually knock a whole country offline permanently. And you only have to have a power cut now in the West for a few hours, and you suddenly think how much we rely on our electricity. You know, suddenly you're reliant on trying to plug the phone into the wall, and you think, oh, I've got no power left. Oh, I can't order anything. Oh, we even end up relying on phones for light very often, just so you can use it to put a key in the door if there's no light. And if these devices suddenly stop working, and if the rest of the grid goes down, suddenly within a few hours everything grinds to a halt. Think of all the business that now is undertaken online in terms of electronic transactions, even more over the course of the last year, as due to lockdown, cash is relied on even less, and it's all electronic online payments. So take that away, and you've got a country on its knees pretty quickly. Similar thing if you were to knock out, say, the water supply. And we've talked previously on this podcast about infrastructure being subject to those sorts of attacks, and there was a US water authority a couple of months back that was subject to a possible attack, and ended up being stopped at the last minute, but that could have led to the whole water supply being jeopardized. Similar thing, gas, or even knocking out, say, infrastructure with regards to all the traffic lights and the way that traffic is coordinated. If that went down, you'd have problems. So an awful lot of damage can be caused through offensive cyber capabilities, and yet that would have a very significant real world consequences for nation states, and far more damage could be achieved through that than could ever be achieved through more conventional means. Indeed, as we've seen with the Stuxnet attack a few years ago, the CIA was able to actually disable a nuclear reprocessing plant in Iran, rather than launch an airstrike, which would have been a difficult thing for the then US administration to do. They just disabled all of the activities within that plant through a cyber attack that took down all of the centrifuges that were in there, so they couldn't keep on doing the important reprocessing they needed to do to produce the uranium, which would have then gone into the nuclear weapons. And that sort of showed, by the time everyone had realised what had happened, the danger had passed in terms of, you know, any potential response by the Iranian state against the US. But this is showing that very much this is the new frontier. This is where almost covert wars will be undertaken, and we know that nation states are always probing out each other's strengths and weaknesses online now in this regard, and it's only going to continue. And at least in this document, the UK is recognising this. It's confirming that it already has significant offensive cyber capabilities, and it's going to draw the governance of those and how they operate into this new agency. So there's still a lot to do. I think the UK is still working out who the friends and enemies are out there. It's taken the decision to rip Huawei out of the 5G communications network and the existing 4 and 3G network as well, which will result in telecoms in the UK getting worse before they get better as they rip out that equipment and replace it. But this is showing the impact now of thinking about where equipment comes from and trying to protect secrets, to protect capabilities in this new environment. And at least the government is thinking about it. At least it's putting serious resources in place to try and do something about it.
Yeah, 100%. I think this is something that a lot of people have been calling for a while, in terms of like a shift from trying to protect this country in the typical way to now seeing that trends have changed in terms of most attacks now take place online. Most attacks are like cyber rather than physical, like they used to be back when the wars were taking place. But yeah, I think it's showing the trend, and that the government are actually taking a knowledge of this now and like making the change.
Exactly. I mean, it's an interesting document they've put together, and of course, the UK government is now thinking about the UK's position in the world, having left the European Union. So this was looking at it from the defence and foreign policy perspective. I mean, it was always felt that before the UK left the EU, it was very much the economic model was as the UK would gradually become a typical European nation. But from a security perspective, there's always been a very clear relationship with the US and the commitment to NATO. Arguably, this document tries to now sort of plot a new path to look at what the UK's priorities should be, who it should work with, and who it should view as a potential threat, or a potential, this document tries to draw a path with China to say, look, we might engage with China on certain aspects of trade, but to realise that also that China has severe offensive capabilities that we have to be alive to. It's going to be a difficult path for the UK to try and travel, but that is the direction of travel that has been set out. So it's a brave position to set out. Let's see now how they get on with that. And I think the investment in defence is incredibly important, both in terms of this cyber funding and in the real world as well. So unfortunately, all these things require funding, and of course, the world is now on the verge of arguably a large COVID recession. So it's a difficult time to be finding this money, but the UK is saying we have to make this investment.
Yeah, absolutely. So moving on to the next story then. So this is in regards to a fine by the Spanish Data Protection Agency. So they have issued their largest ever fine since the introduction of GDPR. So Vodafone Spain have been hit by 4 separate fines that have been compiled into one, and total a total of $9.72 million. Sorry. So this is for over aggressive telemarketing tactics and its failure to protect data. So 2 of the fines, which together came to $7.16 million, relate to GDPR violations. Another fine, which is the third one, is $2.5 million, and this cited Spanish laws on digital rights and telecommunications, as well as GDPR. And then the final fine, which was just under $200,000, actually concerned violations to do with Spanish law regarding cookies. So the cookie law in Spain is similar to the cookie law across the EU and in the UK as well. But I think what is quite interesting here is the amount of complaints made against the company in comparison to the amount that they have been fined. So like I said, the fine is just under $10 million, yet there was only 191 complaints made by customers of the company in order for them to launch this investigation and carry out this fine. So basically, it's just reminding people that it doesn't take a lot nowadays for these fines to be given, and the fact that they have done this. I mean, there was all these fines were in regards to unsolicited calls, emails, and SMS messages without obtaining their customers' consent. So I think it's just the comparison. It is quite a lot of money, but obviously not as big as it would be expected in comparison to like the BA and other fines that have taken place.
Yeah, well, that's a really good point, that it hasn't taken as many complaints as we might have expected. Indeed, if we think back to pre-GDPR, when there used to be the sort of cap in place under previous EU data protection legislation. So in the UK, for example, you could only fine a company up to £500,000. saw, there were far more egregious breaches of data protection legislation back then. Far more complaints could be made, far more people could be affected in terms of affected data subjects. Yet you would only have up to £500,000 fined, whereas in this instance there's only 191 complainants, but a multi-million. I mean, this is showing that the Spanish regulator there is gaining more confidence in using their powers under GDPR. I think it's interesting as well that it's a telecommunications company. We have been helping numerous clients with regards to data protection breaches in recent years, as you can imagine, and it's interesting that some companies sometimes are almost unaware of their obligations when it comes to data protection. They're like, well, we're a telecommunications company, we don't have to worry about these things, and you have to educate them on the fact that you'll find that this appears to be personal data that you've been handling here through the services you provided, and therefore you actually owe some obligations to your users, the data controllers, other organizations that might be using your services. And it's interesting that very often the true application of how far-reaching the obligations under GDPR in terms of data controllers and data processors really are, has very often been missed in certain sectors. Even a highly regulated sector like telecom, they're so wrapped up in individual bits of telecoms regulation, they almost seem to have missed some of the requirements under GDPR, which is fascinating. But this is why it's always interesting when you sort of go and, well, certainly when I go and speak at different industry and sector specific events and start talking about data protection, and there are sometimes certain, I think, preconceptions that people have with regards to the sectors that the data protection legislation applies to, and how they have to be compliant with it. And very often when you explain that no, this does apply, and yes, you can be fined for it, the mouths hit the floor. I kind of see that a little bit here with this, where they simply haven't thought that these sorts of aggressive telemarketing practices would be a problem. When we've seen in jurisdictions across Europe since 2018, these practices have been phased out due to the continued enforcement of GDPR and other associated legislation. It's quite interesting that this was still taking place by a big, Vodafone have presences in multiple different jurisdictions, from the UK to Germany to Italy to Spain, and it is surprising that their Spanish division here, to put it bluntly, thought it could get away with this. But this will clearly be a wake-up call. Not $9 million is not an insignificant sum for them, I'm sure. Though hopefully it will make them change their practices as a result.
Yeah, 100%. And I think as well, there is a lot of fines still to do with unsolicited marketing calls and things like that. I know we spoke about 2 that was issued by the ICO last week. I think they was issued under the PECA regulations. But yeah, it is quite common to think that this law has been around for the last couple of years, and there has been rules in place before that to stop these type of things, but companies still think they can get away with it.
Exactly. So there's still that sort of legacy legislation enacting the old European e-privacy directive, which the directive doesn't take direct effect across member states, so it ended up being local parliaments would then implement that legislation. So it was indeed privacy and electronic communications regs in the UK. There'll be different acts implementing it across Europe, and that's what will have been used here by the Spanish regulator. But also we need to remember that there is the e-privacy regulation is now in draft form and will take direct effect across Europe when it comes in. So that would be across all 27 EU member states plus Norway, Iceland and Liechtenstein, who are in the European Economic Area. So there will be a change coming. And let's remember that e-privacy is specifically designed around communications and telecommunications in particular. It is designed to look at, in particular, practices when it comes to instant messaging, change the communications there in relation to your direct messaging on everything from Instagram and Facebook to platforms like WhatsApp, which WhatsApp wasn't around, social media wasn't around when the e-privacy directive came in the early 2000s, but the idea is that this draft regulation, the e-privacy regulation, would start to look at how those communication platforms are used, and it would have GDPR's fine matrix attached to it as well. So those big multi-million euro fines can follow there as well. So there's going to be more in this sphere. And the fact that we continue to get this enforcement in multiple different jurisdictions around marketing and communications practices, I think shows the need for a more unified approach, certainly across the EU, with regards to that e-privacy regulation. And let's face it, it should have come in at the same time as GDPR. It didn't, because no one could agree on what it should look like. So it's almost sort of been stillborn to this point, but arguably it does now. I think its introduction is becoming quite pressing and quite badly needed across the European Union, and so it'll be interesting to see what they decide to do. It's almost getting to the point I can see the ICO in the UK working with the British government to introduce regulation probably sooner. Goes as far as the privacy regulation or not will be interesting to see.
Yeah, absolutely. So moving on to our last story of the day, and this is just in regards to a few updates on data protection law around the world. So in relation to Dubai, Abu Dhabi and California as well. So starting with Dubai, there has been some new rules for the Dubai International Financial Centre. So this is the data protection law number 5 of 2020, which has replaced a different data protection law. I think it was like something like 2015, or it might have been even 2005. But this basically regulates the collection, handling, disclosure and use of personal data, and includes enhanced governance and transparency obligations. So this is closely aligned with the GDPR and applies to all businesses operating in the Dubai International Financial Centre. So notable provisions include privacy notices, data protection impact assessments, breach notifications and international transfers as well. But the maximum fine is only $100,000. So not as high as GDPR, obviously, but it does have similar obligations. So whether the fine will be increased in due time, we will see. But Abu Dhabi have basically enacted the data protection regulations of 2021 as well. So this is closely modelled on GDPR as well, when having a lot of the similar provisions as what I've just described. And then the final update is in regards to California. So it's just been announced a couple of days ago that California's Attorney General has announced approvals of additional regulations to go alongside the California Consumer Privacy Act of 2018. So they have approved regulations to basically ban dark patterns that delay or obscure the process of opting out of the sale of personal information. So a lot of the California Privacy Act actually talks about like the sale of personal information, onward transfers and things like that. And a big point is that all users have the right to opt out of the sale of personal data, and you must kind of inform users if you are going to sell the personal data on. And there is some quite strong obligations in terms of how you must inform users about this. And basically the new regulations that have been approved just basically add to it and saying that it's prohibiting what companies can do in terms of how consumers can opt out. I think there was finding that a lot of companies were adding unnecessary steps, forcing users to click through a lot of pages to try and opt out, or presenting them with reasons why they shouldn't opt out of the sale of data. So it's just basically helping consumers out and giving them the right again, basically, because a lot of the right was like limited in terms of what the companies were then doing. So yeah, and the CCPA have actually just announced the board appointments as well. And that I just got an email about that for one of the news updates just before I clicked on here. So I haven't had a chance to read through that, but yeah, that's another one as well.
Yeah. I think it's fascinating that we're now seeing CCPA evolve, and we're seeing mean, one of the key things within GDPR is the fact that it gives data subjects significant rights in relation to being access their data and being able to transfer it, in being able to update it and to rectify it. You know, all of these things are sort of quite key rights, and CCPA does take those and tries to do something similar in California, and we're seeing that sort of evolution as CCPA now continues to mature, and indeed as its enforcement outlook develops as well, given they started with enforcement of CCPA last year, showing that, look, this thing does have teeth. Talking of teeth, it is, I mean, it's interesting that in Dubai and Abu Dhabi, they're trying to do something quite brave, I think, to include clearer privacy notices, data protection impact assessments, of which we're always urging our clients to undertake, as well as the requirements around breach notification and reporting, as well as international data transfers, the constant issues with regards to sending personal data overseas that we've covered in some depth on our podcast here, just the complexities between the EU, the US, and the UK. But it's a pity that it's only going to have a maximum fine of $100,000. We know that you know, there are a lot of corporations that have based their Middle East presences in Dubai and Abu Dhabi, and will $100,000 really necessarily be an incentive to make them stop certain practices that they may be undertaking? Arguably, they'll of course make attempts to show willing as far as this law is concerned, but it could be that they won't be quite as put quite as much attention and resources into that as they otherwise would, compared to if we're looking at fines in the hundreds of thousands of dollars, or into the millions of dollars, which is, or even a percentage of turnover, which really makes corporations sit up and take notice, as we've seen with regards to GDPR. Though, having said that, even the billions of dollars that Google faces in that lawsuit that we talked about right at the top of our news update today, you tend to think, that's small change to Google, unfortunately. I'm sure they'll be able to find that quite easily, but you still tend to think that the bigger the stick used by the regulators, the more likely you'll get practical and effective compliance by organisations as well. So it is interesting that it is the Dubai International Financial Centre, DIFC, that's come out with these measures, and that it will, I'm sure, as is happening now in California, these will continue to evolve as well. I'll also be very interested to see what the practical enforcement of them does look like, and what sort of enforcement is carried out, and what sort of things they are choosing to enforce against in terms of the behaviours they're looking at. So yes, the onward march in terms of the regulation of how personal data is handled around the world continues.
Yeah, I think it's interesting as we go along, because obviously we all know that the EU was the leader in this with GDPR, and then obviously the UK, and they've got the Data Protection Act, which is basically GDPR still. But then you see the California, and then you see that loads of different companies coming out with this now, and people are saying the argument that we should strip back the data protection in the UK and tailor it in a little bit to make it more lenient. Yeah, loads of countries around the world are kind of edging more towards GDPR, so the argument kind of gets destroyed in a way, because you would just have to implement even stronger when you're dealing with these other countries. So I think it just shows that GDPR kind of is the way forward continuously, even though now we've left the EU.
Exactly. We talked about this last week, that it might be wishful thinking to think, yes, we can scrap GDPR, but I think you'd find that the main essence of it, in terms of the regulation of data transfers, would remain. You might find some nibbling at the edges where you could afford to relax certain elements of it. But it is very difficult to see in the UK, certainly on the back of that adequacy decision, how you could seek to resile from the data protection regime that we've been following, particularly given that GDPR was just an evolution of the UK's previous data protection law under the Data Protection Act 1998. And the fact that even before the EU, the UK was a leader in the field of data protection, and it is therefore difficult to see how it could seek to, as I say, resile from that position easily. So, yeah, there's not going to be the bonfire of regulation that I think certain parties might have hoped for. And when you see things like this happening in Dubai, you think, well, clearly you'd have to have measures as a minimum like that at a comparable level governing certainly the City of London, in order for London to maintain its preeminent position on the global financial markets, to give organisations and financial services organisations confidence in the regulatory regime, of which, you know, data protection is clearly a part. So that there isn't going to be a significant row back. As I say, it would only be a sort of nibbling at the edges, and nowhere near as great as I think certain people may have envisaged in their mind's eye.
Yeah, absolutely. So that's everything we've got time for today. So just a little reminder, as usual, about our special offer we have on for our listeners. So this is the GDPR compliance manual for legal practices, which is now down to £99. So this contains forms, templates and checklists, and trying to get law firms and other regulated practices kind of understand GDPR and data protection laws. So data protection laws in the UK and the EU are kind of good at saying what the law says, but don't really interpret that into like how you as a law firm or a regulated practice can then change that and kind of put that into your day-to-day work. So yeah, I'll just pass over to Peter just to tell us a little bit more about that.
Thanks, Laura. So this is our guide containing forms and templates and checklists from Anson Evaluate here to give you a practical demonstration of what complying with GDPR looks like in your organisation. GDPR is very good at telling you the standards that you need to achieve in handling data, but it doesn't tell you how to do it. This manual is the how-to in very clear, plain English. You know, these are the checklists to follow. These are some of the forms that you can use. These are some of the practices that you can embed into the way that you are demonstrating compliance. And I mean, we did originally design this for law firms, and we actually took a lot of the things that law firms already do, things like, you know, file audits and managing risk, and we said, look, this is how you tweak those existing things that you're doing and make sure you're also producing outcomes there that will demonstrate compliance with GDPR. So you don't have to reinvent the wheel. It doesn't have to be difficult and complex and time consuming. You can basically demonstrate your compliance through things you're already doing. So that's the sort of good message to take away there. It doesn't have to cost the earth. It doesn't have to take huge amounts of extra effort and resources. And that is the guide on how to.
Yeah, thank you, Peter. Just a reminder as well that this webinar is and podcast is brought to you by Anson Evaluate. So we just wanted to remind everyone that Anson Evaluate is a training and webinar consultancy service. So they actually provide a lot of training to companies on around data protection, on other things as well. Similar to the work we do, but slightly different in terms of it's more training and consultancy services. So if you do want a webinar to be produced, and you're just kind of struggling on how to get that set up, Anson Evaluate is something they can help you with that. So I have left the website and email addresses on the screen there, just so you can get in touch, just at admin@ansonevaluate.com. If you do want any training or anything for your business.
Indeed. So you've got Anson Evaluate, they're producing everything from webinars to bespoke online training systems for different everything from GDPR to other aspects of compliance, and also doing sometimes things in person in terms of going into organisations, helping them with everything from complying with data protection to cybersecurity best practice. And doing in the course of the last 12 months lots of great things online. So take a look at the website, see some of the great things they've been doing, including a Access to Justice Law Tech hackathon. There's a little 1-hour video on there that shows the work that Anson Evaluate did with several teams of law students to teach them how to code, to get them using the Python language, and to start using that to build some platforms that could be used to deliver access to justice for different areas where at the moment it's arguably there is unmet legal need because it's too expensive or too difficult or to be able to get services there. So everything from things like immigration to harassment laws, and trying to provide practical guidance, help and support to people. So some great things to see there on the Anson Evaluate site.
Thanks, Peter. So yeah, that's just www.ansonevaluate.com if anyone's interested. So yeah, that's everything we've got time for today. Thank you once again for Anson Evaluate for helping us produce this webinar. So this webinar is available as a webinar and a podcast, and it's usually posted on our websites on a Tuesday, and then on podcast channels on the same day as well. So thank you for listening, and we will see you next week for another update.